Asante.
So without much ado, I think we just need to go straight. My topic is on the food systems, environment planning, and case law. You have been fed on food systems and been fed on environment planning because you're planners. I think I would rather concentrate a bit on land tenure and the case laws. So I just would like to go straight and ask, according to the new draft land policy, we have a definition on land tenure. And the definition is this. The draft National Land Policy 2024 defines land tenure as the terms and conditions under which rights to land and land-based resources are accessed, acquired, retained, used, disposed, and transmitted. Now, you need to appreciate the first entry point of that definition. Why access? Because in Kenya, we like to demarcate. But now we want planners to help us to enforce Article 40, which recognizes customary land tenure, which was generally about access. Use, when attrition happens, the other generation will come and use. But bringing the Law of Succession Act has actually distorted the customary way of using land, so that the fragmentation mentality has been imposed on us. But our constitution under Article 40 actually recognizes community land rights and customary land claims. We have not yet actualized it, even in the coast. We still have tenants at will. That was not something known in the African culture. We live here, we do our things here, we graze here. When we finish, somebody else, our generation, our children, grandchildren come. So that is why access is very important. Moving, I will not overemphasize, but I think the importance of the action, the environment action plan in land tenure is obvious. Recently, we saw people being moved from riparian land. These are people who have lived on riparian land for the rest of their lives. They know this as their home. So the moment you take them away, their food is threatened, their shelter is threatened, their right to enjoy their country is threatened. And therefore, we are being asked as planners, let us not plan without considering environment impact in our plans, without considering right to food and shelter in our plans. Because when we have a circular plan, we'll be able to do better and actually deliver what we are looking for, secure land tenure. Because at the background of the food, at the background of the environment, we are looking for secure. So that when you're here, you don't feel tomorrow the new county government of Mombasa, which will come with a new policy and you'll be chased away. Because probably you did not support this government. Secure land tenure it doesn't matter the pastel that is happening, the politics, the legal, the social, the economic, you will always be secure because you are a citizen and you have the basic human rights just because you're human or you're an animal or you're a plant. So it tells us that this involves the assessment and profiling of environment concerns, designating strategic interventions to address such concerns. Then Section 40 of MCA, the reason why I felt it was important to mention the sections, because when you are founding a claim or when you want to easily justify, that is the way our mind is trained. As a lawyer, you want to give the section. But our constitution recognizes traditional knowledge and customary knowledge, so that even if it is not codified, it does not mean it is a lesser right. So Section 40 of the MCA provides that every district environment committee shall, but now county, shall every 5 years prepare an environment action plan in respect of the district, now the county for which it is appointed, and shall submit such plan to the chairman for approval, now the county assembly. Then created under Section 37 is that the MCA provides that the National Environment Action Plan Committee shall, after every 5 years, prepare a National Environment Action Plan. Then we move forward to section 2. The action plan will both be long-term, short-term, and intervening. This one is just to emphasize that you cannot have land use planning without putting environment planning. You cannot have environment planning without putting food planning. So the law itself has actually prescribed, if this is a right and a duty which a professional planner has to enforce and benefit from the rights of enjoying a professional certificate, what answer will you have in court when you're told that you approved this plan that does not have these components? Because you're enjoying a special license to be called an environment or a land use planner. And the law gives you that special recognition because you know better than my mother who has taken you to school, or your mother who has taken you to school. So those are the various things you need to consider when you're doing that environment or land use plan. I don't need to go through the justifications because you know them, but I'll mention some key laws. I don't even need to go under the international protocols. You know the Kyoto Protocol, the Paris Agreement, which all of you are talking about now, which is a legally binding international treaty on climate change, which was adopted by 196 parties at the UN Climate Change Conference, the COP21 in Paris, France, on 12th December. The main objective is Article 2, is the stabilization of the greenhouse gas concentrations in the atmosphere at the level that would prevent dangerous anthropogenic. So when you are approving a plan whereby the PDP wants to extract minerals, have you considered that Kenya is already a signatory to the Paris Agreement? Or when you are making that approval, you have blinded yourself from those considerations? So my role is just to activate that when you are doing planning, apart from the obvious pluper, you have the MCA, you have the wildlife, you have the County Government Act, you have the case laws, you have the international protocols. You know, the planner is the main cook. And probably what we are missing is that we are not integrating the value chain of professionals. As most of you are talking here, I could feel the frustration. Madam Joy spoke, Mr. Ambwere spoke, Planner Mairu, and I can't remember his name. They spoke, and nobody seems to have a solution. But the solution is in the law. Enforce the law. Enforce the law. But probably sometimes you do not know how to extract that component called enforcement. That is why integrating ourselves with other professionals so that we can enjoy the full circular economy, maybe integrating, working with a lawyer, working with a surveyor, will be a good thing so that you don't take the entire 46 million. Gawia, Karo, ata milioni mbili, akufanyie legal analysis. So... So I do not want to go on importance of sustainable environment planning on food, because this one is obvious. You know that influencers such as agriculture productivity, resource availability, and resilience ecosystems that support food production are essential to achieving food security for the population growth that we are having, and planning for soil, water, policies. All those ones are important. Again, we go back to secure land tenure. When your plan does not speak to the various laws that govern that specific plan you are approving, probably you want to build a big hotel like this one. And this is an area where in some plan, maybe 30 years ago, was stated to be for Kaya Forest. You will definitely approve this plan. Some conveniences will happen, but maybe 10, 15 years later, somebody will be like, no, but this is protection of Kaya. So what secure land tenure will you have helped the investor that you prepared the plan for? And probably just because you maybe did not foresee that your own approval was actually going against MCA, or was actually going against the customary land rights of the Kaya people. Because initially people have thought that customary land rights are below. They are not. They are just at the same level, even if not superior. And we've seen the Supreme Court. I think most of you know about Dyna management case, which has completely shaken the commercial market. If you followed the town meeting of the Supreme Court judges recently, you saw our own Professor Githu Muigai saying that some of these things are threatening commercial interests because you have already built something on riparian reserve and the beach here. And you're being told that land was not available. Initially, in our initial constitution, whereby first registration was more superior than fraudulent acquisition, Kenyans gave themselves that fraudulent will be a very, very big determiner. And therefore, it is not what Kagema approves, it is not what Mairura approves, it is not what Karo approves, it is what the law says. An approval which does not meet the requirements of the law is nothing less than a paper. So, then we move very fast. Allow me to say something about compulsory acquisition, because I saw here planners coming from the Kenya Urban Roads Authority and various state agencies. Now, compulsory acquisition is an issue of secure land tenure, particularly for the government. If the government acquires land to do agriculture, but then they don't compensate the people, will the government be secure? Initially, in the old constitution, they will be secure, but now, they will not be secure. We've seen many state agencies lose a lot of money because they did not follow the compulsory acquisition to secure tenure, whether it's for agriculture, whether it's for road. So it says it's imperative for acquiring bodies to critically appreciate the Land Act, sections 107 up to 131, but particularly 112 on propriety of investigation and section 27 on dispute resolution. What does 112 say? I'll not read the whole of it, but you can read for yourself. After the notice and all those things which are just mandatory, it says that the notice of inquiry shall call upon. Subsection 2 is very important if you work for a public agency which acquires land. The notice of inquiry shall call upon persons interested in the land to deliver a written claim of compensation to the commission not later than the date of inquiry, and receive claims of compensation from those interested and make full inquiry on the persons who are interested. Then 6 says the public body for whose purposes the land is being acquired. The public body for whose purposes, chief, if Bungoma is acquiring, chairman, if Kimilili is acquiring, the public body for whose purposes the land is being acquired, and every person interested in the land is entitled to be heard, to produce evidence, and call and question witnesses at the inquiry. Why is this one important? We have seen the SGR, the bypasses, various roads, whereby you acquire land only for later on to get evidence that this land was actually surrendered in 1976. For a road, be it the Taj Mall, be it the highway exchange, but money has already been paid. And who approved? Somebody who drew the design somewhere, maybe a planner, maybe a surveyor. Did they do due diligence to determine secure land tenure, whether the government already had that tenure, which are again spending billions of money to acquire? The law again asks that NLC then should recover from anybody who has been paid. But then somebody will be like, no, but you acquired this land in 1976 and left the title with me. It means you didn't need it. So it then leaves you as the professional, because you know that the member of public will not pay anything, isn't it? So it is you, the professional, who will remain with the skunk and an audit query. And it requires that now, how do you always recognize that property in your liabilities as an organization. Let us say Kura. How do you recognize? Let us say Kilifi municipality. Do you always recognize that land in your financial statement under PFM as a liability or an asset? Maybe you always recognize it as an asset. But for convenience purposes, you've decided to block your mind and decide we want to acquire because there's money to acquire. But then you are threatening the tenure of the government even as a public officer. So the acquiring body, you are not supposed to be sitting as a duck. When the people are saying we want to be paid 1 million, you are supposed to be bringing evidence and saying, we think you need to be paid probably 500,000. Or we have actually done further investigation and found that this land is already public land and therefore will only pay you for structures if they qualify, if they did not trespass. Maybe it was through a government policy, they were told squat here, but will not pay you for land. Another thing about tenure, when you are acquiring land, do you, before you pay the leasee, who you had leased to public land, ask them to first of all pay all the rates or the rent? Or the sweetness is always very fast. Let us push, hii pesa itoke harakara, but again you are threatening public land tenure. Just because public you don't see a person, it does not mean that, the money trail, it speaks. The record speaks. Somebody somewhere will be like, yes, when you're paying 500 million, these people owed the government ground rent in terms of 100 million. So for me, it's just to encourage us, let us look at what the law says. Always when I speak to my fellow colleagues, I always say that the allure is so quick, you want to be transactional as opposed to being a lawyer. The role of a lawyer is to advise. The role of a planner is to advise. And you cannot advise until you understand the facts. So before you claim and approve, what is the advisory? And before you advise someone, you must advise yourself. Advising yourself is acquainting with what are the database on whatever you're planning. Then, now, I've already spent around 18 minutes. And I said I'll spend 20. You can allow me maybe another 10 minutes I talk about case law? And we finalize? Members? Okay, thank you. Now, on the case law of Ken Kasinga versus Daniel Kiplagat, whereby the National Environment Management Authority, the petitioner argued that the mast was built without the requisite year, license, and violated the Constitution and the right to a clean and healthy environment. The court found that the mast was constructed without proper adherence to environmental laws and procedures and orders. An investigation into the ER license under the Kenya Information and Communication Act, the telecommunication mast to be dismantled and the site restored to its original position in 30 days. Now, I hear planners talking about things called PDPs. So when this year was set, was there already a plan in that area? What was that area supposed to be used? Did the person who did the year ever look at the plan? Probably the plan may have said something, or was it just that, we just need to approve this thing. After all, this is communication authority. We are being told by the courts that nobody is above the law. Even the government is within the law, and therefore the person, before you append your signature, always look at the database. And the database is what exists, what regulations, what laws, and actually, like Justice Makori said, talk even to the village drunk. Atakuambia mambo ya hapo. Then we have the Mau Forest case. I don't want to read the parties, but it was about a contestation on eviction of individuals occupying land in Mau Forest Complex, which is a key water tower. The petitioners challenged the government's actions, including evictions and forest boundary alterations. They alleged violations of their constitutional rights, including the right to property, housing, and fair administration action. Remember now the rights are fighting. The housing, right to shelter, right to farm, right to food, and then the right to protect the water tower. The evictions were deemed lawful but procedurally flawed. The court directed the government to ensure that future evictions comply with the Constitution and the constitutional imperatives. The NLC concluded that they agreed with the objectors' submissions against allocating. No, this is another case. So now here, when we say that the court agreed that the eviction was right, but the procedure was wrong, it is about procedural justice. Actually, the ELC is having a conference in Eldoret, whereby they are talking about distributive and procedural justice. As planners, you have a lot of regulations and a lot of procedure. You might end up approving something which the approval is correct, but you did not follow the required steps. The people are not given information. There was nowhere you advertise the plan. When you said you can send to Mr. Sindani, my planner from Bungoma, objections, when they went there was nobody to receive. When they wanted to look at the copy where you said they'll get the plans, there was nobody to give them a copy. So those are procedural issues. So the court will say, even though you are right to plan for this area, but because those procedural difficulties, we set aside. And who will be responsible for the loss? Will there be secure tenure for the county government of Kilifi, Bungoma, or Garissa when the procedure is wrong? So distributive justice and procedural justice go hand in hand. Then I just wanted to mention something about conflict of planning and survey. The National Land Commission actually dealt with a case involving Codison. Codison was the objector that they had applied for allocation earlier from the Lamu County government. And actually they had been approved before even the new counties came in under the last local government. And then when the new counties came in, new boys came on the block and somebody else was allocated before them. So when they went to court, the court referred them back to the commission. And when they came back to the commission, the county government of Lamu changed its position. Remember, the county government of Lamu is a planning authority. They are the ones who come up with the spatial plan or the DPs or whatever. But they changed and now they did not want to allocate. So when the commission is supposed to only allocate a plan that is approved and then the owner changes their mind, what does the commission do? Remember, this was prepared, I believe, by the director of planning in Lamu. Obviously, the commission may not allocate if the county doesn't want, but there must be some consequences. So the commission then went for a middle ground and said the county government of Lamu should facilitate amendment of the PDP and subsequent resurvey of the land, retaining A, B, and D, and in the subject PDP, but excluding the existing titles of portion C, where those titles are found. Where can you get this case law? You can get it on the NLC website so that you can read and understand how the conflict between planning, between the law, between the survey happens when we do not follow what you call procedural justice. Because how could somebody have extracted C, a title, without an approved plan? And then we are hearing here planners saying now things are happening without approvals. Now, is it that the law is not there? The law is there. But had Codison not come, would Kenya Institute of Planners have called their own plan and said, but how did you do this? How did you approve a PDP on top of titles? And if the titles were wrongly issued, would they have said, maybe let us refer to the county attorney to first of all go for cancellation of the existing titles which are hanging in the air? They have no PDP, they have no registry index map. And then how did the director of survey approve and authenticate a title which has no PDP. And how did they do it without a master DP? Because I thought a PDP must be based on a bigger plan. Now the bigger plan is not there, but then something. So when you say a part development plan, where is it? Again, procedural issues. So you can see how we cannot work in silos. And I brought to you this matter of Kenya Pipeline, which I did myself. I was the lawyer in the matter. Yes? Yes. Yes, the Kenya Pipeline Company Limited and Judiciary. This matter, the issue is about where the government starts a process. The government in completion of allocation and registration of approved plans leads to disputes even in government bodies. NLC Council took an advisory approach to advise the judiciary to file the documents on the process of how it arrived at the title, advise the pipeline on government bodies' public user land, and relied on the Supreme Court advisory opinion. So when this matter came to me, I called actually Ross Kitur, who was a planner within NLC, and said, but this seems to be a conflict of plans. I called also Sospita, surveyor, and said, what do we do? Because these are two government bodies, and they're not supposed to be taking each other to court, but they are already in court, so we don't need to embarrass ourselves. But then, the AG had not filed anything, because it's like they didn't even know what they're supposed to say. So I said, the best, let us go to procedural justice. Did judiciary acquire this title after due process? Yes, because there was a government memo, a meeting, that pipeline have to be relocated to Embakasi. And now this land is more suitable for the judiciary because the commercial court was too small, so they needed to pick the land next. And when we gave this story through the now registrar of the judiciary, the court agreed and said pipeline had already lost any valid claim because they had been given alternative land. But do you see, if I didn't involve Sospita and Rose, probably I would not have been able to assist. And I chose not to put in a fight, but to use the advisory approach. So for me, I'm saying that let us look at what the courts are telling us. The other matters, you look at them. I don't need to go through them. Apart from Mohammed Badi, you know where the court said that the Lamu fisheries, the Lapset project, they needed to be compensated because their livelihood of fishing, whatever the heritage, everything was being interfered with. And a new year, in fact, SEA, Strategic Environment and Social Assessment, was ordered so that they know better how to do the port without destroying the heritage reserve of Lamu. So sometimes going to court just opens an opportunity to do something in a better way. I have also given you international cases so that you can feel more energized that even this issue of conflict of planning is happening in the UK, in Europe, and everywhere. But in this one, recently just given on behalf of the Council of Surrey, the issue of planning was found by the House of Lords to be central. And it's not just land use planning, but environment planning. And the House of Lords ruled in a majority of 3-2 that the extraction license was wrong for failure to consider environment considerations in the approval. I thank you.